My name is Victor Manibo. I'm a senior attorney here at Wang Law Office, and you are watching the AM Show, Wang Law Office's question and answer show about your immigration questions.
Hi, my name is Ariel. I'm the host, also a senior paralegal in Wang Law Office. Our show is going to start every Friday at 11 a.m. EST, 8 a.m. PST.
The AM Show is here to answer all your basic questions about immigration topics. We mostly get our questions from our viewers and our prospective clients who send them in via YouTube or line. So we encourage you to send those questions over if you have any, and we're going to collect them and make episodes about them about a certain topic. This week's topic, to follow up on the things that we've talked about in the past couple of weeks, is going to be about the EB-1C visa.
Victor, before we actually start today's topic, can you introduce a little bit on your own background?
For those who haven't met me yet, again, my name is Victor Manibo. I've been an attorney for Wang Law Office for 10 years, and I have been an attorney for 12 years. I graduated from Cardozo School of Law here in New York, and most of what I do here at Wang Law Office is immigration litigation, meaning helping people not be deported by ICE by defending them in immigration court. I also do immigration applications, meaning helping people apply for legal immigration status with USCIS. And I do a little bit of crimmigration. That's the intersection of criminal law and immigration, helping non-citizens to protect their immigration status in case they have a criminal case.
To recap, what is the EB-1 visa again?
So a couple of weeks ago, we talked about the EB-1 visa. It's employment-based visas. Preference 1. These are immigrant visas for certain types of people. They're for people with extraordinary ability. They're also for outstanding professors or researchers, which we talked about on our show 2 weeks ago. Today, we're going to talk about the third type of EB-1 visa, also called the EB-1C, and it's for multinational managers and executives. This is fairly similar to the L visa that we talked about last week.
So what is the EB-1C visa?
EB-1C visa is an immigrant visa. So it's a green card for multinational executives or managers. These people have to be employed by a U.S. employer outside of the U.S., and this employer has to intend to hire you as an employee in the U.S. in a managerial or executive capacity, meaning, you are working for a multinational, you're in a foreign country, and the U.S. company that is part of that multinational corporation wants to bring you from the foreign country into the United States. It's kind of similar to the L visa, but the L visa is a non-immigrant visa. It's temporary. EB-1C is the immigrant visa counterpart to the L visa.
So what are the difference between L visa and this EB-1C?
One main difference between the L visa and the EB-1C is that the EB-1C is a green card, therefore the standard is a little bit higher. The requirements are a little more strict. And also with the EB-1C, you can't come into the United States to set up an office or a location. We talked about the L visa before. You can come in, and even if the corporation hasn't been existing in the United States or hasn't been operating in the United States, you can get an L so that you can come in and start the business. You cannot do that with the EB-1C. With the EB-1C, you already have to be, the U.S. corporation already has to be in existence and operating, and we'll talk more about that. But that is one of the main differences.
So what are the benefits of EB-1 visa?
EB-1 visa, which we talked about a couple of weeks ago, and specifically the EB-1C, which we're going to talk about right now, is a green card. It's lawful permanent resident status, meaning you can come into the United States, live here, and work here permanently. You can travel in and out of the United States with very little restriction. You can include your family members into your EB-1C application as derivatives. And when you do get your immigrant visa, you can petition for other family members because it is a green card. You get certain tax benefits and government benefits from being a lawful permanent resident. And eventually, you can also file for citizenship.
So what are the requirements for the EB-1C?
As I mentioned earlier, this is for multinational executives and managers. And with similar to the L visa, this kind of immigrant visa requires a petitioner and a beneficiary. There is the company who is the employer and the non-citizen who wants to get the green card, right? So we're going to talk about the petitioner first, or the employer. The U.S. employer, it should be a U.S. corporation, meaning they have their own legal entity here in the United States. They're not just a branch or a small office by a foreign corporation. They have to be an actual US corporation, and they have to be doing business in the United States for at least 1 year. So it's not a completely new business. It has to be a business that already exists and operating, doing business for at least 1 year. This is why it's different from the L visa, because the L visa, you can come in here and set up the company. Can't do that with the EB-1C. And finally, that U.S. corporation that has been operating for 1 year must have some sort of relationship with the foreign corporation that employs the beneficiary, right? Because we're talking about someone who is outside working for a company, for a multinational. So the U.S. corporation has to be related to that foreign corporation in some way, either like a parent subsidiary relationship or an affiliate relationship, a joint partnership type of arrangement between two corporations. So those are the requirements for the petitioner, for the employer.
So you mentioned it can be a bench office, right? Are there any limitation on the bench office?
Well, branch office kind of just could imply that the foreign corporation just like bought office space here or is renting an office space here, and that is allowed for the L visa, but that is not allowed for the EB-1C. Again, it has to be a U.S. corporation, meaning number one, it has to be a legal entity that is registered under the laws of the state where it's located. It has to be a separate corporation from the foreign corporation, but they still have a relationship. It's either this U.S. corporation owns the foreign corporation, or the foreign corporation owns the U.S. corporation, something like that, or they are both in a partnership where both corporations own 50-50 of the entire enterprise, something like that. So again, the limitation is that you cannot just have a branch office of a foreign corporation here. It has to be a U.S. corporation that is its own thing.
So that corporation in the U.S. need to doing a business, right? What does doing business mean?
Doing business in the United States. This is actually the language in the regulations. Doing business means that the corporation is operating in the United States in the provision of products and services. It exists, again, as a legal entity, right? Because it's registered. And there should be regular, systematic, and continuous provision of goods and or services. So you can't just have, a U.S. corporation on paper that, bought a building, right? It has to have employees. It has to have a product or a service that it is providing to the public or to other corporations. The U.S. corporation basically has to be, again, a functioning business. That's what doing business means. Again, this is different from the L visa, where somebody can come in here and set up a business that isn't operational yet. The EB-1C requires that the business is doing business and has been doing so for at least 1 year.
We mentioned the requirement for EB-1C petitioner. What are the requirements for the beneficiary?
So we talked about the employer. Now we're going to talk about the employee. This is the non-citizen who is working for the foreign corporation, right? There are two major requirements for this employee. Number one, the employee must be employed outside the United States by the foreign corporation for at least 1 year in the last 3 years before you file the petition. So this is, again, similar to the L visa, right? Or if the person is already in the United States, maybe they came in on an L visa or another type of visa, and they're already in the United States, they have to be working for at least 1 year in the past 3 years since they got admitted. So they have to be working for that foreign corporation. So it's, again, the number is 1 year for the last 3 years, employed outside the United States with a foreign corporation or employed within the United States by that same foreign corporation. And now they're moving to the U.S. corporation. They might be moving from the foreign office or the foreign corporation into the United States, or maybe they're already in the United States and just moving to a new function under the US corporation. But you still have to follow that timeline. So that's the first requirement. The second requirement is that they will be working in a managerial or executive capacity, meaning the transfer from the foreign corporation into the US corporation is because this employee will become a manager or executive. And this is, again, something that you have to prove that you are a manager or an executive. And there are very specific requirements about that.
So what does managerial capacity mean?
So managerial capacity is the term that's used in our regulations. And for someone to be eligible as a beneficiary of the EB-1C, they have to show that they are either a manager or an executive. A manager is someone who has managerial capacity. This means someone who has the ability to supervise and control the work of other employees. Now, there are very different kinds of managers, and there are very many levels of managers, right? There are sometimes when you go to a fast food restaurant, there is a manager and there are the cooks, and the manager looks over the cooks and the cashiers, right? That's a manager because they're supervising and controlling the employees. However, EB-1C is geared for managers on a higher level than that. You have to be supervising and controlling the work of other supervisors or other professionals or other managers. So you are the manager of managers, or you are the supervisor of other professionals. And by professional, we are talking about people who have specific licenses or degrees that are a little bit high level. If you're supervising doctors, if you're supervising lawyers, those are what we call professionals. These are the types of managers.
So what you mean is you're going to be the big boss, and then you have some small boss below you, and then the small boss have the employee below you.
Yeah, so exactly that. It's managers, but not all managers. We're talking about high level managers. You have the authority to supervise those other lower level managers. You have the authority to control them, to hire them or fire them. And also you have some authority in controlling how the business works on a day-to-day basis, about the operations of the business.
So what does the word executive capacity mean?
So executive capacity, again, this is another term that's in the regulations. And this is kind of similar to a manager. An executive comes from the word execute, meaning they do things. They are one of the people who do things for the company at a high level, performing certain functions that are essential, that the company, the corporation will not be able to do its business without this person. Again, we're talking about high level people who control, who operate an essential function of the business. That's one. And also they steer the direction of the business in terms of coming up with the policies of the business and how the business is run as a whole. So we're talking about CEOs, or VPs of a corporation, because they're very high level. They do very specific essential functions for the corporations. Another sign that someone is an executive is if they don't really have bosses above them. So basically they're kind of the big boss. Maybe they have, their boss is the board of directors of a corporation or the stockholders of the corporation, meaning aside from those, there is no other people above them. So that's usually what executive means. Again, the EB-1C is intended for these high-level managers and executives. The EB-1 in general is intended for high-level people, really talented athletes and artists and researchers. Same thing here, really talented and important managers and executives of multinational corporations.
So what is the process for applying?
As I mentioned earlier, the EB-1C process requires a petitioner, which is the U.S. employer, and a beneficiary. So this is kind of like our family-based petitions that we were talking about before, right? You have to have a U.S. citizen or an LPR relative who's already here in the United States, and they're petitioning for their relative. So think of the U.S. employer as the petitioner and the relative as the beneficiary, right? So the first thing you need with a family-based relationship is the familiar relationship, right? You have to be married or you have to be like the child, right? So here you have to have that relationship between the U.S. employer and the employee who's working for the foreign corporation. And what is that relationship? That relationship is a job. So very first thing you need is a job offer from this U.S. employer saying, hey, you are an employee of a foreign corporation that we are partners with. We want you to come to the United States to do a job for us. We are offering you a job. We will hire you for this job. Do you accept it? So that is the very first thing you need, that kind of relationship between the petitioner and the beneficiary. And once you have that job offer, then you can proceed with filing the EB-1C application papers. It requires a petition from the employer. This is kind of like the the family-based petition, and it also requires the green card application or the EB-1C application from the beneficiary.
So can I file the petition or the green card application together at the same time?
In family-based cases, we've seen this and we've talked about this before. You can file the petition and the green card application together, right? For EB-1C, you can also do that together. Petitions, just like family-based petitions, they have a priority date and they have to be current, meaning your place in line has to be now before you can file a green card. But in general, for EB-1 cases, it's almost always current. It's generally current because the U.S. wants to encourage these high-level managers and executives to come to the United States to do business here. So, the wait time for the priority date usually is non-existent. And if that's the case, if the priority date is current, then the employer can file the petition at the same time as the beneficiary files the green card application or the EB-1C application. However, if it's not current, if the priority date is not current, and we can talk about priority dates at another time, if the priority dates are not current, then you have to wait until it's current before you file your green card application. So you file the petition first, get it approved, and when the priority date of that petition gets current, then the EB-1C application for the green card can be filed.
So what kind of document I need to prepare?
We talked about the eligibility requirements earlier. So the documents that you prepare are the ones that can prove that you are eligible, both you and the employer, right? So first, you have to show that you are employed for the foreign corporation for at least 1 year in the past 3 years, right? So that can be your resume can prove that, some documents from the foreign corporation, letters from your foreign employer saying, yes, this person has been working here for the last, X number of years, as long as it's at least 1 year, right? And then you also have to show that you have experience as a manager and as an executive, right? Because this visa is for multinational managers and executives. You have to show that you've been supervising people in the foreign corporation, that you have experience as an executive running a business at high level, right? You can also show managerial or executive experience by giving your resume, by showing your college degrees. If you have awards as an executive, those also will show that, yes, you are a manager or executive, you're a high level person, right? And then as an employee of a foreign corporation moving to the United States, you have to show that you have a job offer in the United States from the US corporation. We talked about this. This is the relationship. So usually that job offer comes in the form of a letter from the US employer saying, we are offering you this job. This is the title. This is your function. This is the salary that we're paying you. These are the terms of your employment, right? And those mostly so far that I've talked about, those documents are for the beneficiary side. For the employer, you also have to provide some documents. The U.S. employer has to show that they are in the United States, they are a registered business in the United States, they are their own separate legal entity from the foreign corporation. So they have to show their articles of incorporation, they have to show their organizational charts, they have to show their business license in the United States, right? They also have to show that they have been operating, doing business in the United States for at least 1 year. So they have to show okay, their financial reports, what kind of money are they making and where are they making this money from, right? So if they're selling products and if they're providing services to the public, because that's required for doing business, if they have products and services, there should be money moving in and out of the corporation.
Mm.
Those financial documents are going to show that. Also, you have to show, this U.S. employer has to show that they have a relationship with the foreign corporation, right? Because it's an intercompany transferee. So they have, the U.S. employer, the petitioner has to show that they are the parent of that foreign corporation, or they are the subsidiary of that foreign corporation, or they're an affiliate of that foreign corporation. So again, the incorporation documents, their business plans or organizational charts are going to show the relationship between the U.S. employer and the foreign corporation. And you have to prove that so that you can petition for someone.
It's a company in the US. You might have a company tax return that can be approved too, right?
Oh yeah, absolutely. The tax returns show that, number one, you're a registered corporation, and number two, you have, some cash flow and you are doing some sort of business in terms of providing products and services, that there is money that is being made, and that's why you're paying taxes. So those are the basic EB-1C requirements for the beneficiary and employer. But at the same time, because this is an immigrant visa, because this is a green card, the beneficiary also has to show proof of other basic green card requirements, meaning you have been inspected and admitted. If you are already in the United States, you entered legally, you are not inadmissible for certain problems like unlawful presence or fraud or criminal history. So you might need documents for those as well.
So is the application process different if I'm already have an L visa and I'm working in the US already?
Yes. So the L visa, we've been talking about it a while because it's related to the EB-1C. It's very similar. And also because it's a common path that people do. They get an L visa first, they enter the United States to work here temporarily, and then they apply for the green card through EB-1C. If you're doing that, it's basically a two-step process. You have to get your L visa first, and you have to get that approved, and then you come in here, right? And then you work here. And before you can apply for a green card, you have to show that you've been working for at least 1 year for the last 3 years since you came in. That's one, right? I mentioned that earlier.
Mm-hmm.
And you have to show that the company itself has been in operation doing business for 1 year. And then meet all the other requirements. And if you do, then you can apply for the EB-1C. You still have to have the U.S. employer file a petition for you. It still has to be current. And then you can file the EB-1C, which is going to be an adjustment of status application, which we talked about before. If you're already in the United States, it's the process by which you change from one status to another. In this case, it's going to be from L to EB-1C. But you still need a petition from the employer, and obviously to meet all the requirements.
So what if I'm already in the US, but I don't have the L visa? Is the EB-1C application process going to be different?
It's going to be slightly different. For some people, they might be already in the United States on another status. Maybe they have H-1B, maybe they even have B visa. You can adjust your status and get EB-1C. You will still need the employer to file a petition for you, and the petition still has to be current before you get to apply for your adjustment of status into EB-1C. But it is possible. Obviously, if you're here on another status like H-1B or B-1, you have to think about, okay, is this expiring soon? And also, am I going to have unlawful presence if I overstay? Because unlawful presence could make you ineligible for EB-1C. You also have to think about, if you're here on an H-1B or a B-1 or any other visa, what have you been doing? Have you been working for that U.S. corporation for 1 year in the last 3 years? Because if not, then you might not be eligible for the EB-1C after all. So it is possible, but there are other considerations to think about.
So what if I'm outside of the US?
If you're outside of the US, so you're working for the foreign corporation, right? And the US employer that's related to that corporation gives you a job offer or move to the United States, they file the petition first in the United States, and then when that's approved by USCIS, your file gets moved to the consulate or the embassy where you're located, and then you have to do your EB-1C application through consular processing. You're filling out forms and you're submitting documents not to USCIS, but to the Department of State. It's a similar but slightly different process, and you go through a medical exam and interview at the consulate or the embassy too. And when you've passed all of those, then you are issued your EB-1C on your visa. It gets attached to your passport, and then you can come into the United States. So it's slightly different, but the requirements are the same.
So what if I'm in the US already? Can I work when I'm waiting for my approval?
Can you work while you're waiting for your EB-1C to be approved? Well, that depends. For example, if you have an L, then yeah, you can work. You can continue to work for the U.S. corporation, or if you're still working for the foreign corporation that's related to the U.S. corporation, you can continue to work as long as that L is valid. If you're here on a B, you can't really have any sort of employment. B visas are restricted; they can't have any employment, but you can start a business. A business is not necessarily. It's not employment, Employment is, you have a boss who's paying you a wage or a salary. A business is not employment. You are doing things on your own, right? So you can get income from that. You can work in investing in and building your own business. But again, if that's what you're doing, then the question arises like, well, one of the requirements for EB-1C is you're working for a foreign corporation or the US corporation for like 1 year for the past 3 years. If you're doing your own business, then you might not be qualified for EB-1C under that requirement, right?
So if I am in the US and my I-140 petition, the EB-1C application is pending, can I switch the employer?
Right. So this is something that could happen because applications take a little bit of time to be adjudicated and granted, right? So for example, if your U.S. employer already filed the I-140 and, maybe you are already in the United States, maybe you have an L or some other visa, and then you get a job offer from another unrelated company that's going to be paying you a lot more money. And you're like, oh, I think I want to get that job. So is there a possibility to take that job offer and still have your petition pending and the EB-1C application pending? It's possible. It's possible to switch over or carry over your I-140 pending or even the I-140 approval, but there are specific requirements. The new job offer with that different corporation has to be similar, and you have to prove that it's similar. You have to make an extra application to USCIS asking them basically like, hey, I know I have an I-140 filed by this corporation, but I want to switch. So that's kind of another request, another benefit, not a benefit, but like another application that you have to file to USCIS with supporting documentation. It's a little bit complicated. So that's why it's not always advisable unless they're giving you a lot of money, but it is doable.
Yeah, you need to find a lawyer with experience to do it if you really need to do it.
Right.
So can I include my family member in my application?
So for EB-1C, if you're the beneficiary, you can include your spouse and unmarried children under 21 in the I-140 petition. Obviously, you have to tell your U.S. employer, hey, I want you to include my spouse and my children. And if you are including your spouse, you will need documentation such as your marriage certificate. If you're including your children, you have to make sure that they're under 21 and unmarried, and you have to provide proof of relationship as in their birth certificates. If you get approved for the EB-1C and they're included in the I-140 petition, they will also get EB-1C status. They're going to have the same category upon approval and will have the same benefits as the primary, as the beneficiary, the employee.
We talked about EB-1C today, and it is a green card path for the high-level employee of multinational company who wants to live and work in the US for a long time. So there is a path become a US citizen too. If you think that you meet the requirement that we just mentioned earlier, you should call us to schedule an appointment with a lawyer with experience on such thing. And today, time is up. If you have more questions, you can feel free to leave your question with any of our platforms.
Yes, please let the questions keep coming. We appreciate everyone's questions through Line and YouTube and email. And we're going to make more of these episodes. I know that employment-based visas and NIVs are complicated, and we're happy to answer all of your questions. Again, as a reminder, everything that I say here is based on my legal experience and my opinion, but it is not legal advice. Even though I am happy to answer these questions, it's not legal advice, and it's not legal advice that's specific to you or anyone's case, and it is not legal representation. It doesn't mean that I or Wang Law Office represents you just because I'm answering these questions. However, if you want legal advice, if you want advice specific to your case, if you want a lawyer to represent you, please feel free to call us, and we would be happy to talk to you about that.
And you can continue to follow us on YouTube. And thank you. See you next time.
Bye.